Well, good afternoon, everybody, and welcome to today's webinar. We've entitled it Elections and Social Media, Navigating the Legal and Ethical Landscape. And with less than 2 weeks out, this is a very, very important issue. And I'm absolutely delighted that so many people have decided to join this discussion this afternoon. I'm Jeremy Maggs, I'm the host, and I'll be facilitating the conversation between our panel members. Let me introduce them to you. We have Asma Kachalia, Director in the Employment Law Practice Area at Cliff Decker Hofmeyr, along with Farad Bayat, Co-founder and CEO of Farosian, Africa's first social digital media risk screening company, along with Megan Camphor, an associate at DML, focusing on litigation and commercial law. A little later on in the webinar, I will introduce you to Alan Mouton, who specializes in Lexis RefCheck, and he'll be giving us some details as far as that particular issue is concerned. So what are we going to do here today? We are going to cover the potential risks associated with social media use by employees. I want to look at legal frameworks surrounding the freedom of speech, the effectiveness of social media screening in employment, and the necessary guidelines and training for maintaining a positive corporate image without infringing individual rights. That, let me say, is quite a mouthful, and by the looks of that, we probably need more than an hour to get through all of this. But having said that, let's do our very best as far as that is concerned. Just 2 points that I want to raise before we start. The second thing is, the first thing is, I keep a very close eye on the Q&A box, and that's where I'll be able to act as an interlocutor between yourselves and our 3 panel members. I do not look at the chat box at all. The chat box is for you to talk among each other, raise issues and concerns, but I'm not going to look at that. And I will do my very best to get to all the questions and to put them to the experts if I possibly can. So with that, Farad, let me start with you then, and let's wade straight into it if we can. Some of the main risks maybe that companies are facing when their employees are active on social media, particularly over an election period. I think the answer is pretty obvious, but just remind us.
So thanks for being here, Jeremy, and thanks for everybody for having me. Social media is a very difficult place for people to navigate. They don't seem to understand the, let's call it etiquette that should be involved with it. What we see in our line of work is that there are certain trigger points, or what we call milestones, in terms of increase in negative content that people engage with and post. And one of those, a key one, is election season. Prior to election season, during the elections, and post-elections, you start to see a lot of rhetoric and posting and content that is in favor of the person's aligned political party, political views, and they don't understand that those views border on and cross the line of hate speech and or discrimination based on things such as political affiliation. And in the South African environment, racism becomes an enormous part of it. So crossing that bridge and being able to have oversight or awareness of what people's posting is from an employee perspective becomes exceptionally paramount. That in turn has negative consequence for a business. Loss of revenue, loss of credibility, loss of reputation. We've seen it through hundreds of instances. You just think back, Penny Sparrow, Adam Katsavelos, numerous people. Businesses have endured and encountered millions of rand of lost revenue and damages from a PR perspective.
Asma Kachalia, I wonder if there are signposts to know when you have crossed that bridge that Farad talks about, or is it a moving target?
Well, what's important, Jeremy, is you have to understand that employers are using social media firstly to promote their brand and advance the business at the outset. So it's a very important tool that people use in any event. And they sometimes also encourage their employees to join and encourage their employees also to try and promote their brand, which is what you need to do when you are an employee. Now, there's specific things that you cannot speak about, and that's that must be very specifically laid out in policies in terms of your particular place of employment. And that's why things like social media policies, and I think Farad will go into that as well a bit later, but all your policies, all your workplace policies should speak to what can and can't be said in social media, on your specific platform, whether or not you're affiliated with just yourself or with your employer in a public forum. And that must be specifically spelled out, because what eventually happens is people claim defenses like freedom of speech and privacy and such, and we need to make it clear to all employees what can and can't be said in terms of the business and what is best for the business. So making that clear is a very important thing an employer needs to do at the outset. Some things are a bit obvious, but some things just need to be made clearer.
Megan Kampfer, where is the line, if one exists, between freedom of speech, as Asma has just raised, and being a complete idiot?
Well, Jeremy, thanks for that question. If only it were that easy, you know.
Thought you'd say that, yeah.
Yes, we would have much easier time and a quieter practice if it were that straightforward. But in fact, it is not. Our social media use in our country is not regulated by a single law, but in fact by a web of laws. We've got the Constitution, we've got the legislation, we've got judicial precedent, custom. So when it comes to freedom of speech, we need to start with the Constitution. And the Constitution clearly and explicitly protects our right to freedom of expression, but it also has a very express exclusions. And one of those express exclusions is hate speech. And if I can just refer to section 16.2 of the Constitution, the right to freedom of expression does not extend to, firstly, propaganda for war, incitement of imminent violence, or then the last big one, which is the topic of today, hate speech, which is defined as advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. So that must be clear to most social media users, but it is not. And so we see how the legislature has expanded on that. We'll call it a prohibition, although the Constitution doesn't necessarily act as a prohibition. It only gives us a definition of what is not included in the right to freedom of expression, which takes us to PEPUDA. That is our Promotion of Equality and Prevention of Unfair Discrimination Act. And that gives us a good definition of what hate speech is, which is the advocacy of hatred based on race, ethnicity, gender, or religion that constitutes the incitement of harm. So in a clear layman sentence, it means that I hate someone based on a certain characteristic which they have. There's a difference between expressing hatred to someone just for the sake of it and expressing hatred due to a specific ground or something that they associate with or how they identify. And then that takes us to the new and very fresh assented to bill, the Promotion of Equality and Prevention of Unfair Discrimination Act, which has now expanded on the grounds on which hate speech can be found. We now have, I think it's 17 grounds where if I express hatred and that incites, harm as a result of my expression, based on one of those 17 grounds, I'm very much in deep waters, and it will be difficult to step away from that.
Farad, I'm wondering to myself, particularly in this maybe hyper-tense time ahead of the election at the end of the month, what organizations then need to do in order to either change their control strategy or up or improve the way in which they're monitoring. Is there anything more that they can do? Because that is fundamentally pinning or underpinning the reason why we all gathered here this afternoon.
It's a great question, Jeremy. We like to believe that something called a digital risk ecosystem should be employed within any organization. And that comprises of three main components. The biggest component is the implementation of a social media policy. It's effectively your internal rules and regulations for usage of social media. The second component, and this is an exceptionally important component, is a lot of organizations make the mistake of, one, implementing a policy that is not robust enough and does not speak to the alignment of the additional policies already existing within the business. Because social media is an area where any of those policies can be breached. Now, you cannot implement or should not implement a policy of such robustness and detail without implementing effective training on the social media landscape for people. Now, unfortunately, most people who use social media do not clearly understand the landscape. And I'll use this analogy. Most people have cars or drive a car, but they don't know how to fix it. So just because we use it doesn't mean we understand the inner mechanics and workings of it, right? Social media is no different. Just because someone has a Facebook or a LinkedIn profile does not mean that they are an expert or even have a decent depth of knowledge of how it works. So upskilling them and training them on things like privacy settings, the legal consequence of posting whatever types of content becomes paramount. And the third part is an underpinning monitoring, if you want to put it like that. A lot of companies over the last 10 years have started implementing social media screening as part of the recruitment process. Now that helps to mitigate your risk for people coming into the business, but it doesn't mitigate any risk for existing people in the business. So we believe social media screening should be a component for recruitment purposes, but also at least on an annual basis, because something like social media, it's not like a criminal check or a qualification check that doesn't really move very much for the majority of people. Social media, people could be posting 400 tweets a day. Tweets of different themes, different natures. It could be illegal in nature, could be hate speech in nature, it could be innocent. So with that amount of data and information that is being communicated on a daily basis across multiple platforms, it is something that does require a little bit more frequency in terms of its monitoring.
Okay, so let's extend your motor car analogy, Farhad, if we can. So it would be incumbent on any organization, if they're driving this beast, to have a motor plan. And part of that motor plan is the policy, right? Who's in charge of the policy, or who enforces the policy within an organization? Because often I have found in my reportage of this particular incident is that it falls between stools. You know, people will say, well, it's an IT issue, it's an HR issue, it's a legal compliance issue. And as it falls between the cracks, that's where the reputational damage occurs.
Yeah. So that another fantastic question. We've seen over 10 years that the buck is almost shifted from one area to the other within a business. As soon as you say social media, immediate thought is marketing, right? And then it's from marketing, it gets pushed on to HR, and from HR potentially to legal, and from legal to risk and compliance. Ultimately, it depends on the DNA of the organization, and it depends on the structure of the company. But a firm belief that I personally have is that it should lie within potentially 3 different areas, or jointly accountable within 3 areas, and that being legal, that being risk and compliance, and that being HR, because those are the 3 elements that are most at risk in terms of it. HR has a responsibility by the internal employees within the organization, and there's an impact to legal and risk and compliance based on people's activity online. I don't think it's a situation where it's a sole ownership by one area within the business, but it should be a joint ownership with joint input into, 1, the construction of the policy, and 2, the constant updating and revision of the policy. because it should be at least annually updated, simply because legislation changes. As Megan said, the hate crimes bill has been put through, and that is something recent. So that also has to be adapted into the policy. When you have changes to things such as the Criminal Procedures Act or Road Traffic Management Act, that is affected by people's online behavior. So just as internally within a company, policies need to be aligned, the legislation also needs to be aligned, which means the policy needs to be adapted. And finally, with regards to it, the platforms themselves, Facebook, Twitter, Instagram, TikTok, they're constantly changing their terms of service, their conditions of use, their community guidelines. And with those changes, the policy should also reflect those changes. So the
Asma
ownership.
Kachalia, I wonder if I could bring you, thanks Farhad, Asma, if I can bring you into the conversation, maybe just pick up on what Farhad was talking about. It's all very well to have the lines of demarcation of responsibility within an organization, but it's about the policy itself. And he spoke about it being more robust. What is your understanding of a more robust policy?
Well, like I said, Jeremy, it's you can only, when it becomes an issue is when an employee is doing something and believes that it really isn't in the interest of the employer to get involved. For example, when I post something on social media, it's my private time, it's separate from my working time, it's my expressed views, and I want to make them known. What an employer needs to do in these cases, whenever they're faced with this kind of situation, is be able to draw a nexus or a connection between what an employee is doing and how it affects the workplace. And a robust or a sound social media policy explains to an employee in no uncertain terms that when you post something, you need to understand that you're doing it and it can affect the way that somebody looks at the organization that you particularly work for, and accordingly affect the relationship that you and I have as employer and employee, and it would put your employment into jeopardy on that basis. But they need to make it clear to an employee that you not fixing your privacy settings, or you not understanding or being tech savvy, because these are all excuses that people have used in the court. They've said, I'm not tech savvy enough. I didn't know I was actually posting this just to the open public. I thought I was just doing it to 3 people. It's outside of my workplace. These are all excuses or defenses that employees have used in previous cases where they've said that you can't possibly discipline me for this. And employers need to make sure that when they explain the policy and they train them on it, that they understand that what they do can have a negative impact because it impacts the business. And it needs to be something that's that sort of addresses all of these specific defenses, and then also is like Farhad said, it trains them on how to stick to privacy settings. It trains them on what they can and can't do, so that they really don't have an out when it comes to these specific things, and they've just posted something willy-nilly. I think that's what it means. It needs to be clear enough for an employee to understand. They need to be trained on it. And when you are confronted, say, in a forum like either the Labour Court or the CCMA, a commissioner and a judge need to understand that this was a clear rule that was breached. It can't be something that could have been somewhat ambiguous. So that's where your starting point should be as an employer when you are developing a social media policy or something that speaks to that.
Asma, isn't everything you do ultimately always going to reflect on the company? Is that you're inextricably linked to that company during your period of employment, whether it's something as innocuous as complaining about a meal at a restaurant, it can still thread back to the organization, can't it?
It can. It really can. And the thing is, and that's when it becomes a case-by-case basis. When you're trying to look at specific things that people have said and how it affects. An employer also has a duty to sort of justify why it affects the business as well. So while we are limiting freedom of expression, we can't do it to the extent where we as an employer are being a bit ridiculous as well. But yes, you are correct. Everything you do when you join an organization, whether that organization is plastered on your social media page, Asma belongs to CDH, and or not, there will always be a link, and that's why you have to be extremely careful before posting anything. And I mean, one of the biggest cases is when, I think it was very soon after the Penny Sparrow post that Farad mentioned, there was somebody who made a racial remark and referred to President Zuma's government as monkeys. I think it's the case of Cantor Mesa versus Edcon Group. And it was done after hours. It was done because she was frustrated, and she made that comment, and it had nothing to do, she had no nothing that linked her on social media to her employer. But the court found in that specific case that is online, that is misconduct. They found that it could be it's a dismissible offense, and dismissal was reasonably justified in that particular case, even though all of these defenses were raised by her. So it's absolutely true, Jeremy. Everything you do does reflect on your organization, and you need to understand that before you post anything. Yeah.
Of the almost 200 participants that we've got this afternoon, one of those people is Heinrich Badenhorst. Heinrich, thank you for your question, first of all. I'm getting to that now, but you asked, will we have access to the recording? Some of our HR managers, you say, couldn't attend, and they can already, or you can really see benefit in it. Yes, absolutely. The LexisNexis team will take care of that. And I'm glad that you're finding it useful as far as they're concerned. Having said that, Heinrich, and maybe Megan Camphor, you can pick this up. Heinrich says, if you screen someone's social media, are we not breaching their privacy and then transgressing the Protection of Information Act? Is there a line, or is the line moving all the time?
Yes, Jeremy, I think from an internal employment screening perspective, Farad will be better to cover that aspect. But in terms of your privacy, so when it comes to privacy, we need to understand the concept of your legitimate expectation of privacy. Of course, privacy is a constitutional right enshrined in the Bill of Rights. It's quite important, an important right when it comes to social media use. But when we think of privacy in the area of social media, even if I'm an employee, the aspect of or the concept of a legitimate expectation of privacy depends on my conduct of what I do with my social media, what my privacy settings is, where I am making a statement, or to whom I'm sending an image. If I go and make a very public post about my employer, which has the potential to harm its reputation or might amount to defamation or hate speech, and I make it on a platform which is set on public, and I have 10,000 followers, if I get attacked on my post, and that is challenged by the subject of that post, I cannot really I can raise my privacy, but my legitimate expectation of my privacy being protected is far less than when I have my little Instagram profile or a private LinkedIn profile where I have 100 or 50 followers, and I raise an opinion, or I make a statement, or perhaps the same type of offending statement, and that gets screenshotted and shared by some follower, and it gets shared all around, on the platform. It ends up in the newspaper. I've got a stronger ground to stand on to say, well, that person who has screenshotted my statement has actually infringed on my right to privacy, and my legitimate expectation of that right being protected is stronger. Now, when it comes to screening, and again, I think Farad would be better to say, but from my point of view, I would think that If your internal policy or your employment contract says that your employer has got the right to screen your social media platforms, which are perhaps on public settings or which are used during the course and scope of your employment, I can't really raise my privacy right being infringed when that actual screening takes place, especially if I give my employer a reason to screen my platforms.
Farad, I'm going to throw this to you in just a moment, but Megan, one more quick question. Does the legitimate expectation of privacy depend on a person's profile? So if a person is a public figure, for instance, surely they would have less of an expectation of privacy than someone who is not.
So at the core of that, we must think of who has the right to privacy. And that is every single South African, whether you are a political public figure or whether you work in the bank or whether you are a freelancer working from home. You will never be in a situation where you have no right to raise your privacy. But when you find yourself in a situation where you have a very public-facing occupation, then you need to realize that if, for instance, you are a political figure and you have shared something that is quite contentious or something that might amount to defamation, it's not that you won't be able to raise your right to privacy if you share that statement or that remark on your profiles. It's not that you can't say that you can't raise your privacy rights, but your risk of that right being infringed is much larger because you've chosen the forum in which you share it. So you need to understand that when you've got a lot of eyes on you, you need to be more careful of your actions, and you might not have as a robust argument to make when your privacy is being infringed as the freelancer at home who sent an email to a colleague about, being disgruntled about something of their boss, or, well, this is a freelancer, but you get the idea. So we will always have a right to privacy. We should just be careful of the forums that we use, especially if we find ourselves in the eyes of the public.
Farad, Bayat, do you want to pick up on any of that, and particularly on the issue of screening?
Sure. I think some very good points were raised by Megan. To almost get to the public figure aspects first. There's, as Megan rightfully said, some occupations require that you are more public facing than others. But ultimately, there are various things that need to be considered. And one of those things is that we have to realize having a social media account makes you a celebrity. You might not be Cristiano Ronaldo or Kim Kardashian level celebrity, but you are a celebrity within the circle of the followers that you have and the connections that you have. That's the first thing. So an individual needs to make a conscious decision of what is their purpose of having social media. Do they want to grow their following, which in turn reduces or increases their responsibility to limit their privacy within a certain sphere of their life? Ultimately, from a legal point of view, and Asma and Megan can correct me if I'm wrong here, please, it is the account holder's responsibility to determine their privacy settings. It is not dissimilar than making an insurance claim for a house robbery, but you left your doors and windows wide open and went on holiday for a month. So a right to privacy and the privacy of information, the onus is on the account holder's responsibility. It's on them to set that. We do not have any recourse if we just leave our car in a parking lot with the keys in it and the doors wide open and then go to report to our insurance company, oh, my car was stolen. They won't pay our claim. We still have a responsibility that is associated with us. Social media is not a different place. People forget the responsibility that they are taking on board by opening such a profile in an account, and what their level of activity and participation in their own protection should be. That's a very important part that I think people miss. And from the screening side, I think there has to also be made a clear distinction. There are organizations who are conducting social media screening internally, and that in itself becomes a problem. It becomes a problem from a potential bias that can be inflicted on the person being screened because of things such as protected information, the elements of protection in the Constitution and in the hate crimes bill. Something as simple as viewing internally, a hiring manager, a line manager, viewing a candidate's or employee's social media and finding out their political party association or affiliation or belief system is in direct opposition to the person viewing it, creates inherent conscious or subconscious discrimination or bias against that candidate. So separating it between it being conducted internally as opposed to externally is extremely important. Externally, there are professional standards and legislation compliance that has to be adhered to. An external third party will not include protected information as part of the reporting process. They will have a quantifiable measurement and metric to use. It's to sort of explain that. It's similar to somebody saying, oh, you can give this person credit, they're a good payer. But what's a good payer? That's why credit bureaus exist, because they have a number to reflect the person's creditworthiness. Similar scenario here. And thirdly, an external or third-party provider conducting such work should always and only report on public domain information. So if it's not publicly available, it shouldn't be accessible by the third party conducting the screening, which almost negates the or makes moot the point of the privacy side. Because number one, it is the account holder's responsibility. And number two, if it's being done ethically through an outsourced function, then it is not being accessed if it's not public domain information.
Right, thank you very much indeed. Asma, I do love a blunt question. And my thanks to James Sabia, who's asked exactly that. You might or might not have seen it. Very simply, he says, can an employee have a political opinion on social media? In other words, promoting or saying what their preferred political party is. And here's the rub, without any fear.
So
now, I know that from a freedom of speech point, of course they can, but it's more complicated than that, isn't it?
Yes, well, it is, and my example on the EdCon case was one, is that having a political opinion on a party that you specifically support without it moving into the realm of hurting anybody in particular, saying something that might be defamatory, saying something that might be derogatory. Because remember, we talk a lot about our freedom of expression. We talk about our freedoms that are enshrined in the Bill of Rights, and they're there for a reason. And a lot of it is because of the landscape that we previously lived in. And that's why we're allowed to say specific things. But there are limitations to that within the Constitution as well. And that is limited by Section 36 of the Constitution. So you can express an affiliation that you might have, but it cannot go into the realm where it starts to become detrimental or it starts to become disparaging. And that's pretty much what had happened in the EdCon case when what she specifically said there was, look at this monkey government. I mean, you can't say something like that, even though it clearly shows what political party she may have supported at that specific time. So it's very important that what you say needs to be said in a way that will not sort of infringe on anybody else's right. And remember,
in a judicious and responsible way.
Correct.
Fair enough, I understand that. But who makes that determination? Your definition of judicious and responsible could be very different from mine, particularly, let's bring it back to the election, at this heightened time. It's very difficult to prove, is it not?
Yeah, so I think what an organization needs to do, and you are 100% correct, Jeremy, and that's why a lot of this goes to the courts, and a lot of people fight about what they said and try and make a case for what they said being absolutely fine. And it's the court that then ultimately has to determine whether this falls within something that's acceptable in an organization or not. But your policy needs to explain to employees why specific things can't be said. And there must be a reason that your organization would not want you to say specific things. And what I'm saying maybe is that stay away from taking those positions. But at the same time, I don't want to limit anybody's freedom of expression or anything like that. But just be very wary about, and if you do feel like it would move into into something that may not be accepted by your organization, don't say it. Stay away from that. I hope that answers your questions. The very straightforward
Asma, sorry,
question.
I did lose you for a moment there. I do want to come back with a follow-up though, and I was just thinking that all very well to be temperate as far as this is concerned. I get that, I understand that, but how do you explain that to a millennial or Gen Z that has a very different approach? They comprise an important part of the workforce, and they live predominantly their lives online. It would be a different mindset, a different mentality, surely.
Yes, and that's why your social media policies need to move with the times as well. And
but
they need
often
to be
that doesn't
updated.
happen.
It doesn't. That's precisely right. And it needs to move with the times. People need to understand. And that goes back to your question about who's the custodian of this particular policy within your organization, and how many people need to come together to understand how it works. And then employers need to understand what should be considered misconduct and what maybe can't be considered misconduct given our sort of new age way of communicating. And when I started off with my presentation, I almost said that we rely so heavily on social media to promote our own brands as organizations. So we need to understand that we're working with something here, and our policies need to almost echo the same thing. And while millennials and it doesn't, the good thing about sort of hate speech and derogatory comments is that it's not going to change ultimately. When you say something and it's hurtful, it always sort of stays hurtful. And so people need to kind of understand what they're saying and when they're saying it and how they're saying it, and not just use sort of freedom of expression and that sort of thing as an excuse to just to hurt somebody. Our code of good practice against harassment protects mandates an employer to protect employees from that kind of hurt as well. So employees must also remember that what they say, whether they consider it expression and whether they consider it whatever they do. I'm a millennial myself, so as I understand, but you need to understand that what you do, an employer is sometimes duty bound to protect other people. And when you are infringing on their rights and other employees' rights, an employer needs to step in there and say, whoa, as much as you want to say this, you cannot. And the degree of disciplinary action against that person will obviously depend on the circumstances of each of those particular posts. So again, I'm not saying don't say anything. I'm just saying you have to be careful as much as you want to say something, express something.
Asma, I'm a baby boomer, and while we're disclosing our different demographics here, and I just shake my head in confusion sometimes. But that's why I get to ask. That's why I get to ask all the questions. Farad and Asma, I want you to think about this. Megan, I'm coming to you now, but we've kind of dealt with policy, and we've dealt with approach, and we've dealt with difficulties. I want us to start thinking about what a company does when there is transgression, what approach and recourse there needs to be. But Megan, what about the old disclaimer? So Lucas Skippers writes, some users have, in inverted commas, views on my own. Does that carry any value? Is that any defense? Would it clear them if there's a problem? Does it legally protect them, or does it mean nothing at all?
Jeremy, let's look at the transgressor. If your statement is, if I make a statement and I say these views are my own, okay, that's not going to help me for personal action against me, because it actually deepens my hole. If I
Yes,
make
it does, yes.
Yes, if I make a defamatory statement, or if I say something that amounts to hate speech and I say that these views are my own, I'm not going to walk away from that personally.
But does it distance you from the company, I think, is the question that Lucas is asking.
So this is the other side of the coin. From a professional point of view, from your employment, we need to think of, you know, firstly, what is the tie with the company? And it doesn't necessarily, we have to think of the aspect of vicarious liability. If I make that statement whilst employed, I have a valid employment contract with my employer, I make the statement during the course and scope of my employment, and I've actually made the statement myself, it might help you if you need to say that I distanced myself from my employer when I made the statement, but it isn't a headshot. It's not a silver bullet. Ultimately, when we see the inside of the court with some case of defamation brought against the employer and the employee, and the employer is implicated by vicarious liability, if my rights are infringed by that statement, it comes down to a balancing of rights. It comes down to a contextual assessment. We look at the surrounding facts. So a disclaimer might help the company in some sense to try and walk away from anything that might have gone wrong from that statement, but it isn't a headshot, and it certainly isn't going to help the employee in their personal capacity, if that answers your question.
I think it does. Followed by it, let me come back to you. Let's talk a little bit now about dealing with transgression. So let's assume that said employee says that they feel that X political party is doing a terrible job and they want to disassociate themselves from that organization, and potentially says, I speak for my entire company. And the government then withdraws valuable work from that company. Damage has been done both financially and reputationally. What then should the employer start to do in that respect? Are there set guidelines that should be put in place? Or, as Asma said a little earlier, all of this so much is on a case-by-case basis?
I think it's a bit of both situation. I think each unique situation needs to be assessed on its own merits, but at the same time, I do believe that you can have some sort of high-level risk mitigation strategy in place. And again, that strategy should be outlined, at least at a very base level, in your detailed and robust social media policy. So the policy should also outline instances of, if there is a case that is starting or has gone viral because of an employee, regardless of their seniority, they could be the front desk person at a JSE listed company, or they could be the CEO. The only difference between the level of the person is the speed at which that will go viral. The CEO's content will go far more viral at a higher rate of knots than a front desk person's. We then need to also assess the nature of it. If it's a situation like you described, well, then that becomes a situation where there is financial loss associated to the company as a direct result. And there has to be some sort of process in place that if somebody's activity and behavior online, inside or outside of working hours, using company equipment or not using company equipment, there's still an association between that individual and that organization of what the consequences are. So the training and the policy becomes even more important in these types of situations because it helps you to be directed into your course of action. If it's a case of limiting the impact of a viral piece of activity or content that is causing damage, well, then you need to get your legal department involved and your PR department involved. And one of the worst things an organization can do in those sort of situations is remain silent. At least issue some sort of statement stating we're conducting a detailed investigation, we have our attorneys on this, and we've contracted the use of an external social media investigations company to further investigate this. Give constant updates and provide as much information as possible to the public, especially if it is widespread in the public domain. If it's not as widespread and it's not in the public domain, it can be handled internally, but again, linked to the internal social media policy that's been adopted.
So, Asma Kachalia, then, are there specific steps that would need to be included? Farad called it a crisis or crisis mitigation strategy. I would say a crisis management protocol. Yeah. Let's call it what we want, to handle controversies stemming from social media. And please, if you could come at it from a legal perspective, where would you start building those blocks?
So in terms of how you deal with a specific person who was the transgressor, our Labor Relations Act has specific ways on how to deal with discipline of misconduct. And one of it is in our Code of Good Practice is that you have to hold some sort of hearing or allow an employee to respond. And that's when the investigation and you listening to what the employee has to say or have some sort of say to respond to the charges that have been put against them. That's when that opportunity comes in, and that's within our Code of Good Practice in terms of dismissal. So you would have a person who would be charged for something and given an opportunity to respond on that. What stems from that, and in the scenario that you painted, is quite a hectic one in the sense that the person said this, and
I'm a journalist. What can I say? I deal in hectic.
It's like there's no sort of room for him to kind of defend it. He put it all out there on social media and he pretty much said what he wanted to say. And that would be sort of, so an investigation process does happen where you look at what was said and you understand it. Now so that's how you deal with the employee in particular, because that employee needs to be disciplined as per your disciplinary processes and procedures. And a lot of that stems from the Labor Relations Act, where it tells you that they need to have an opportunity to respond to this. So before you dismiss them, you need to allow them to speak and tell you what happened and why they did what they did. And that's where they raise their particular defenses. Now, from a crisis management perspective, Farad's quite right. There could be specific things that you would do within your organization. But one of the things that I did mention previously is that you need to show that you are dealing with the situation as an organization. And one of them is to deal with the person who has transgressed. So an employer has a duty, especially when it affects maybe another employee within the organization, and that employee is specifically aggrieved and raises it. An employer needs to show that they are doing something to try and manage any hurt or harm that was caused by the transgression that this particular employee might have done. In terms of how it's harmed your business, that's not within sort of the Labor Relations Act, but Farad has done it. That would fall to your PR. But your duties as an employer in terms of the Labor Relations Act, in terms of the Code Against Harassment, is to take action and protect your employees and protect your business. And that's sort of the way that you would deal with it. And that would be part of your social media policy. But like Farad said, it would also speak to your disciplinary code, which all employers know they have to have as well, on how to deal with instances of misconduct.
You've got to be seen to be doing something. That's the most important thing. Megan, Farad, and Asma, I'm going to ask you, please, to start thinking of some closing remarks in this respect. And for our participants today, maybe the best way to do this is, what's the call to action here? We are living in a very fraught 2 weeks ahead of the election and beyond the election as well, as things start to move in this country. It's a climate where so many transgressions can occur. What's the call to action here? What would be your best advice? So if you can start cogitating on that, I would be very, very grateful. In the meantime, that other person that you see on your screen is Alan Mouton from LexisNexis. And Alan, you're going to give us a sense, if you can, on RefCheck, Lexis RefCheck, and how this can interface in helping people deal with some of the conundrums that we've raised this afternoon, right?
Yes, Jeremy, that is correct. I'm just sharing my screen quickly. Just need to show you some slides. Let's go. Okay, so thank you so much for that, everybody. And thank you so much to the fellow panelists for giving your insights. I've actually learned something that I have not learned in the past before, working with social media checks now for about 5 years. Just to give you a bit of brief background myself, my name is Alan Mouton. I'm an account manager at LexisNexis, looking after the Lexis RefCheck product. So after this session, if you want to reach out to us, we actually encourage that. So please reach out to us for a one-on-one session where we can discuss your needs. So when we look at social media on the Lexis RefCheck platform, there's certain things that we do look at. Farad, please feel free to jump in here. Farad and myself, we do work hand in hand, not on a daily basis, but whenever the need arises for the past 5 years. So if you look at the legislation part of the report that we do provide on Lexis RefCheck, the first one is your hate speech bill, and there's 7 categories of hate speech according to the Constitution. Factors, hate speech is like the identity factors of an individual or group, including religion, ethnicity, nationality, race, color, descent, gender, but also characteristics such as language, economic or social origin, disability, health status, or sexual orientation. Some examples, if we have to look at the hate speech bill when it comes to social media, is with the elections approaching, we see an increase in the posting of these types of behaviors, which can carry risks for both the person and the employer. Increased amounts of defamation of politicians is seen, and content with a high potential interpretation as race discrimination. The Form and Publications Act, the panelist has also explained that in detail, but how we look at it as an example, we would look at what people do not understand is that by posting content, liking and sharing, they're a publisher of content, which is very, very important. There exists a possibility that people can be held accountable for sharing content to the same extent as the original poster. And then for the Employment Equity Act, discrimination can take place where there is an internal screening, which also takes place, as protected information can be viewed and internal biases can occur, a difference in a political opinion of support. On the next slide, screening of the product. So when we access the product through our service provider, we access only public domain information. So there's no hacking and there's also no forcing of friend requests. That's why the importance of the information you input is critical. We find online evidence of discrimination, illegal activities, and also illicit content. We provide you with screenshots for evidence, a risk score, which is dependent on the frequency and the severity of the content on the different platforms. And the implementation of the product is screening employees before hiring. You mitigate the risk of a bad hire or a person engaging in highly negative content. And we also utilize a digital risk assessment. What we mean with that is be proactive in the awareness of behaviors which are misaligned to the organization's value or culture. And also, due to the nature of social media and how quickly content and activity is added, a person's risk profile can change very, very quickly, especially during times that we can experience on the 29th of May, such as elections. Social and digital media risk is something which moves daily. What I'm going to do now is I'm just going to move over to the system itself, which is called Lexis RefCheck. And I would just like to show you how to access the report from our side, or how to load the information. So the first vital information before doing any check on Lexis RefCheck is a consent form. We require a permission from the candidate in order to run the check. The consent form, in essence, how can I put it? It protects you as the user from a company and also protects the candidate. So what we would do over here, just need to move that, is I will select social media. Moving down, we've got different type of reports that we do have that we can offer at the moment. We have your standard premium, your full, and also your full premium, which is available on the system. But we also have an AI report, which we have used with different clients as well, which have proven very effective. It's not yet integrated into our system, but we are moving towards that direction. That's why I'm encouraging you to reach out to us. So me and Farad can come and have a session with you to discuss those reports and also what it entails. The information that we would require from you is the province where the individual is based, the mobile number, the email address, academic institution, if the person studied at a university, let's University of Victoria, highest qualification, I'm going to select a degree, the year qualified. So basically you would just put in the information that we require. The company name meaning where the company they are currently employed at. The duration, the job title, and also the manager of the individual. Once you've clicked on submit, we will then send the information through to our service provider, which is Farad, and then they will compile a report for you. And Farad, please jump in if I do miss something. Our service provider checks the following platforms: Facebook, LinkedIn, Twitter, which is now X, Google+, YouTube, TikTok, and LinkedIn. We will then provide you on that report a social media assessment score on the basis of racism, religious hate speech, homophobia, and also the publishing of false content. And on that report, when it comes back to you, it takes about 3 business days for us to provide you with that report. You will be then able to make your decision moving forward with the new hire of the employee. Thank you. That's it from me.
Alan, thank you. Alan, thank you very much indeed. Just very quickly, the quick poll question there. Would you like to receive a phone call from a consultant? It's a yes or no. If you could let us have that information, we will act accordingly on that. Megan Camphor, let's get some closing thoughts from you, please.
Thanks, Jeremy. From my side, I think I'd just like to say that the election season is very contentious. We, of course, see a lot more engagement on our platforms. We see from our political parties' side that there's a lot more investment in digital marketing, which includes social media use. So we can't run away from it. We need to engage, but we need to know how to engage properly. So from an employee perspective, we need to realize that our freedom of expression is not an unfettered right. It's not absolute. It can be limited in many instances by the Constitution itself and by other laws that prevents us from saying and doing certain things. But just educate yourself on the parameters. What is defamation? What is hate speech? Where do the lines? Where do I meet those lines? And from a business perspective, run your ads and your campaigns and your social media posts and your digital marketing past your legal counsel. It's as easy as that. As I said, we've got a myriad of legislation applying to social media law from different aspects on different facets of social media. And it can be complicated, but when we know where the parameters are, we should be okay. But it's an open and democratic society. We need to engage. We need to debate. It won't be helpful if we sit in our corners and don't want to get into the boxing ring.
Precisely, but do it responsibly. I think that's the important thing. Megan Camphor, thank you so much indeed for your participation this afternoon. Farad Bayat, very quickly to you because I see we are almost over time.
Thanks, Jeremy. So my final remarks are that I think we just need to encourage upskilling, education, and awareness in the space. As Megan said, there is a large number of bits of legislation and laws governing social media. There's not just one. Having people have an overview of it is paramount. If we protect our organizations, by protecting our people first, so that they don't commit career suicide now or in the future and affect their future earning potential. We're going to have a better society. We're going to have better organizations. Social media is now the place where everybody spends a large chunk of their time. So let's just learn how to use it properly. I've also seen a bunch of questions just quickly, Jeremy, in the Q&A. Unfortunately, we cannot get to them at the moment, but if anybody would like, I'm happy to spend some time with you through connecting with Alan to respond to any of your questions.
Farad, thank you very much indeed for that off. And again, yes, unfortunately, time is against us on this one, but if there are key questions there, we do appreciate you reaching out. And finally, from the millennial perspective, Asma Kachalia.
Echoing pretty much what my colleagues have said already, but remember, you're an ambassador. As an employee, you're an ambassador, whether you've publicized that or not, you're an ambassador for your organization. And you need to remember that before you post. And for employers, remember, take caution when you discipline, but make it clear to your employees what they can and cannot do. And yes, keep that in mind.
Thank you very much indeed. And to all of our participants today, and we appreciate you being with us. We hope you've learned something. And I also do appreciate the very positive remarks that we're seeing in both the Q&A and the chat box. Thank you very much indeed. And at this point, I am going to call an end to the webinar. Thank you very much indeed. And goodbye, everyone. Thank you.
Thank you. Thank you very much. Goodbye.